suggestion made by my senior was that the neck of the ODM party is the aggrieved party. I wish to invite the tribunal to have a look at paragraph 4 and paragraph 12 of the statement of claim that is filed in this case. Paragraph 12 in particular contains the course of action, because it is common knowledge that every pleading that originates a suit must have a course of action. The course of action, as contained in paragraph 12, followed by 13, relates to the meeting held by the NEC on 11th of February 2026 and the resolution that followed. That resolution is why we are before this tribunal. If you also look at the prayers, which are, and specifically prayer 1, the complainant seeks to have a declaration that that resolution be declared to be null and void. So therefore, it beats all logic to try and suggest that the NEC is the complainant or the aggrieved party for that matter. Having settled that issue, Chair, in our appeal, we are basically stating that there was non-compliance with Section 42A of the Political Parties Act. It's a well-known section. It has been litigated all the way to the Court of Appeal. And Section 42 and subsection A, as amended in 2022, clearly provides that the tribunal shall not hear or determine a dispute unless a party to the dispute adduces evidence of an attempt to subject the dispute to internal political party dispute resolution mechanisms. The key word is an attempt. And from the submissions that I've had this morning, coupled with the pleadings filed, it is very clear that there was no attempt. In actual fact, paragraph 15 of the affidavit in support of the complaint all to invoke IDRM. There are a whole list of authorities that have been rendered in respect of that issue. I would wish to invite the tribunal to have a look at our case digest. Authority 2, 3, and 4 speak to the issue of an attempt. And in particular, the second authority, which was decided by this tribunal, Chabere and 15 others, versus the national chair, ODM, this tribunal held very clearly that the amendment that was made in 2022 was made to enhance party harmony and cohesion. It was therefore imperative for this complainant to demonstrate that he made an attempt. And in making an attempt, it does not mean that that attempt has to be considered. That is why that proviso was put in place. So we submit that there is no demonstration of an attempt. We go further to address the issue of whether or not NEC was the final port of call within the party. It was suggested by my learned senior that there was no follow-through once NEC made a decision. I wish to invite the tribunal to have a look at Article 88 of the ODM Constitution.
Article 88?
Yes, 88.
88.
Yes, that article, Chair and members, clearly provides for amicable dispute resolution. And even further, it goes on to say that any dispute that cannot be resolved by party organs shall be adjudicated through arbitration. So in the first instance, members of the party and members with the party organs are encouraged to do IDRM, but where that fails, there's even the process provided for arbitration. The claimants did not pursue the provisos of Article 88, and therefore it cannot be hard to say that there was no room for him to initiate or to follow through on IDRM. There is a recent decision that was delivered by this tribunal on the issue of attempt. It was delivered in November of last year. That is Harrison Abo versus Nicholas Otieno Owaka. And the tribunal was very clear that there's no room for the tribunal to exercise any discretion once it is satisfied that there's no attempt at IDRM. So, Chair, we submit on that issue that there's been no attempt at IDRM. The law is clear. The issue of jurisdiction is settled, going as far back as the case of Lillian S. And we therefore submit that the preliminary objection should stand, and this claim should be dismissed for want of jurisdiction. Chair, in the remaining minutes I have, I'll go to the second issue, which will then be amplified by my colleague, Mr. Mondi, on whether the rights of the complainant were infringed and whether Article 74 of the ODM Constitution was violated. Chair, I would wish to invite the tribunal to go to the claimant's own document at page 82. Starting from page 80, we find the resolution by the NEC. That is why the reason why we are before this tribunal. In an SMS message that was sent via WhatsApp, the agenda was set out for that meeting, and as part of the agenda, it was indicated that there would be a discussion on matters arising. When you look at page 81 of the complainant's bundle, under resolution number 6, the issue of the removal of the Secretary General came under matters arising, which was part of the agenda. It is also important to mention that the SG was given full opportunity to attend that meeting. He chose not to. And in the replying affidavit that we filed at paragraph 5, that is the affidavit of Ali Madaro, we clearly indicate that the resolution of the NEC was subject to the provisions of the party constitution. And that is what the resolution also says. So that our argument remains that under Article 74(3), the complainant had the right to be heard. That right could not be exercised because the complainant rushed to this tribunal, essentially on the same day that that resolution was passed. So we have an instance where, Chair and members, the complainant does not attempt IDRM at all and admits to it in his pleadings. We have a situation where Article 88 of the ODM Constitution provides clearly for IDRM and also an alternative process of arbitration. We have an assertion made in the replying affidavit that the complainant was to be afforded an opportunity to defend himself. He, however, rushed to this particular tribunal. So in sum, as I close on my arguments, we argue that no final decision had crystallized. If the decision was final, it would have been ratified. It has not been ratified. The internal appellate architecture of the ODM party has not been fully exercised. And for those reasons, we submit that this complaint is premature and is for dismissal. We'll invite the tribunal at its own time to look at the submissions we filed, which are fairly extensive, and the case law that we submitted on the 3 issues that we presented to court for adjudication. So I'll stop there and hand over to my colleague, Mr. Mondi.
Okay, thank you, Mr. Makol.
Thank you, Chair.
and members. Chair, in respect to the question as to whether the complainant's constitutional and statutory rights have been infringed, and whether Section 74 of the Constitution has been violated, I want to give brief submissions. My senior, SC Okero, started by invoking some interesting concept of ostrich equivocation tactics by the ODM party, the first respondent. Chair, by the end of my brief submissions, I hope to have persuaded this tribunal to invoke, expound, and find that the two public policy doctrines, that is of ex tupi causa and ex dolo malo no oritur action, basically meaning that no action can arise from a dishonorable cause, and that a based legal conduct.
Mr. Moody, I don't know if it's only me, but I seem to be losing you.
I too am having difficulty. Sure.
Yes, Mr. Moody, just come again from.
Chair, I was saying that by the end of my presentation,
yes,
I would wish to have persuaded this tribunal that it does invoke two critical doctrines. The first one being the doctrine of ex tupi causa non oritur, that's a Latin legal doctrine, essentially meaning that no action can arise from a dishonorable cause. And the second doctrine of ex dolo malo no oritur, that a court cannot assist one whose claim is based on his own illegal conduct. Chair, I shall be persuading the tribunal also to be conscious of the fact that in crafting the enabling statute, that is the Political Parties Act, number 11 of 2011, that the framers, that is Parliament, had in mind the issue or the aspect of having disciplined political parties that would engage in programmatic competition. The key word is disciplined political parties. Yeah, that is a concept which I honestly believe was borrowed from one of the renowned political economists, Joseph Schumpeter, who really emphasized on the significant role that is played by disciplined political parties in the process of good policy formulation. And finally, I shall be persuading you, this tribunal, that the complainant's conduct is inimical to an ordered and disciplined ODM party, so that the first respondent's National Executive Committee, NEC, had a reasonable basis for initiating the removal proceedings. We honestly submit that the complainant's constitutional and statutory rights have not been infringed or violated. We have demonstrated that under Article 74 of the party constitution, the first respondent had the power to initiate the process of removal, and that the complainant's right under Article 47 of the Constitution, as read with Section 4 of the Fair Administrative Actions Act,
of course, read together with Article 74, sub-article 3 of the party constitution, in terms of issue of a notice to show cause, all these rights are intact.
Mr. Mundi, you know that we are recording. The speed at which you are moving is making it bit.
So,
Yes, you could try just to pace a bit. So you were saying that under Article 74 of the ODM Constitution,
ODM Constitution.
Yeah, the process of removal could be initiated by ODM.
By the ODM through the next.
Yes.
And that in so doing, the complainants